Earlier this week, I was reviewing some documents getting ready for a meeting with a prospective client. And this particular individual had sent me the will that she had written about 20 years ago. And as I was reviewing it, I noticed the will was going to leave things in trust to her daughter. But then when the daughter passed away, it was going to leave things outright to her grandchildren, the testator's grandchildren. This would be the daughter's children. And so I pointed that out in the meeting, and I just said, under the current plan, here's how things would work. And we talked about that a little bit. And then she posed this question to me. She asked, which way is better? Should I leave things in trust or should I leave things outright? Well, ultimately, she decided to leave things in trust to her daughter and her grandchildren and have that trust continue potentially for several generations. But I don't know that there's a hard and fast answer that's going to apply to each and every situation. I think there's some factors that you need to consider. I think one factor you need to think about is, what are you leaving? And another factor is, who are you leaving it to? So for example, if you're going to leave somebody $100 or maybe $1,000 or $10,000, maybe it's $100,000, who knows? Maybe that gift is perfectly fine to be left outright. But also consider, who are you leaving it to? Does that person have any existing or potential future legal problems, financial problems, marriage problems? Is there something that may arise in that person's life that could put that gift at risk? And if so, a trust may be the better option for you in that scenario. Now, frankly, if you're going to leave somebody $100, it's probably best just to leave it outright. Give them $100 and let them go. But what a lot of families are really worried about is they want to make sure that the gift that they leave doesn't provide an opportunity for a third party to swoop in and cause some issues for the beneficiary and put the money at risk. And so what a lot of families do is they create what's called a beneficiary-controlled trust. This particular trust is drafted where the beneficiary is also the trustee of the trust. So, for example, you leave things to your child, but you leave it in trust, and you name your child as the trustee of that trust. And this gives the child a lot of opportunities to have control over the investments of the money, how it's going to be invested, what it's going to be invested in, how it's going to be used, when distributions are going to be made. But it also gives them the opportunity to maintain the protection around that money for things that are remaining in the trust. And so for a lot of families, this is really their ultimate goal. They don't want to create a lot of overt complexity, but they do want to make sure that whatever they give their kids is going to be protected. So I think the most common scenario is that I'm going to recommend is it's probably best to leave things in trust to your child or your spouse or your grandchild, whomever that may be. Name that person as the trustee, considering there's no issues with them serving in that role. And that's going to accomplish most families' objectives.